They're down to the final phase of the double murder trial of Paul Bernardo. Tomorrow, summations will be heard from the defense and the prosecution, and then Associate Chief Justice Lesage will charge the jury. That jury has sat through 53 days of testimony from 86 witnesses over the past 3 months. Much of the testimony and evidence surrounding the deaths of teenagers Kristen French and Leslie Mahaffey has been shocking, to say the least. And testimony from the main witness in the trial, Karla Homolka, over her role has raised anger. Petitions demanding a public inquiry into Homolka's plea bargain deal are circulating in several Ontario communities and on the internet. To discuss all of this, we're joined now from her office in downtown Toronto by defense lawyer Karen McArthur.
Hi, Mike.
Karen, this is Paul Bernardo's 31st birthday. You've been watching this trial very closely. Is there any doubt in your mind that one of his birthday presents this year will be a guilty verdict from this jury that's heard all this testimony?
Yes, there is a doubt in my mind. There is a doubt in my mind. The Chief Justice or Associate Chief Justice Lesage will charge the jury that they must acquit if they have a reasonable doubt. The obligation is on the Crown to prove the case against Paul Bernardo on the murder charges beyond a reasonable doubt. And you really have two witnesses there. You've got Karla Homolka, who is present, and you've got Paul Bernardo. And each have presented their versions under very lengthy cross-examinations to the jury. And I think most members of the public who watched Karla Homolka's testimony were left with a feeling that she wasn't totally credible, nor was her story very compelling. And so then you're going to have to ask yourself, can a jury, properly charged, convict Paul Bernardo on the basis of not very credible and not very compelling evidence?
Do you think then that Paul Bernardo might walk?
No, not walk. I think obviously because he has conceded in his own examination in chief to Mr. Rosen, his lawyer, that he did do the acts of forcible confinement, the dismembering of Leslie Mahaffey's body. He will obviously be convicted of those charges, and because they are acts of stark horror, he will receive a very lengthy sentence for those acts. But there is, in my mind, as a defense lawyer, at least a possibility that if the law is properly applied here and one considers the evidence that's being presented, that he will be acquitted of the murder charges.
Well, since we don't have capital punishment here, I think most Canadians assume that Paul Bernardo is going to be in jail for 25 years before he sees the light of day. But if your assessment is accurate, what sort of situation would he be in terms of parole, if what you predict turns out to be true?
Well, he would be, I would think that if he's convicted, obviously, as I've said, he will be convicted of the acts of forcible confinement, kidnapping, etc. He will likely receive a sentence of life imprisonment. However, that doesn't mean life imprisonment without eligibility for parole for 25 years, as it would in the case of a murder conviction for first degree. What it will mean is that he will not have eligibility for parole for 7 years. That's the law in Canada. And because of the victims groups that will likely come forward at any parole hearing, he will likely not see the light of day for a good many years after the 7 years, even if he were to be acquitted of the first-degree murder charges.
That's quite amazing. Now, speaking of parole dates, it's possible that Karla Homolka will be out in less than 2 years, by July 6, 1997. I'm amazed by that.
That's right. She could be back amongst the rest of us applying for jobs at various battered women's shelters, as she has told us all that she would like to do very soon. And I'm sure that's quite a startling proposition for many members of the community, having heard what she had to say on the stand for many, many days. Most people are not pleased. I
would think a lot of people would find that absolutely astounding. A lot of people find the 12-year sentence itself astounding. But what about this idea of reviewing the deal? What's the real story there? What could be done? What can be done by the Ontario government in terms of the deal with Karla Homolka? The real story there, from a lawyer's perspective, is that Premier Harris, the Attorney General, cannot do anything to effect a change to the deal once it's been entered into and carried out before the courts. We are well past any 30-day appeal period that the government would have had to appeal the deal. She has testified in accordance with the terms of the deal. The only hitch there is whether or not she perjured herself, and the issue is whether or not the Crown could prove that she had perjured herself, even were there to be an acquittal of Mr. Bernardo on the first-degree murder charges. All that would suggest would be that the jury had a reasonable doubt as to her story, and therefore he was to be acquitted. That wouldn't mean that they were convinced beyond a reasonable doubt that Ms. Homolka had perjured herself. So that deal will not be revisited. So that means this public campaign is virtually impossible to achieve its objective. What about Karla Homolka's parole date? 97 is the earliest. What about keeping her in jail until the very end of her of her 12-year sentence. Is there any way that that could be affected?
That is something that can happen, particularly if public pressure is applied. It is a discretionary issue. The parole board considers submissions for many participants. There is pressure now to broaden the people from whom they can receive submissions before someone is eligible for parole or before the parole is actually provided. And so that is a possibility that she could be kept longer rather than being released sooner. And I think that is something that the public would be better advised to pursue than the petitions that they've been circulating, although I'm not chastising anyone for what they're trying to do in circulating the petitions. I'm just suggesting that nothing positive will come out of it in terms of revisiting the deal. For people who think that plea bargaining arrangements shouldn't occur behind closed doors, something may well come out of the petitions.
Well, how did she get a deal that was so soft? It's astounding. The people who made the deal with her obviously knew what she had done. How did she win them over to get such a soft deal?
She bought into people's notions of women as victims, women as subordinate players, women as not equal participants in partnerships. They bought into very stereotypical notions about womanhood, and she has received the benefit of those views. She suckered everyone. I mean, we heard evidence that she's in the top 2% of the population, and I'm sure that the senior members of the Attorney General's Department are very bright as well, but one certainly has to question what they did and why they did it.
Karen McArthur, fascinating. Thank you for joining us today. I look forward to talking to you again on this trial.
You're welcome, Mike.
Bye-bye.
All right. Thanks, Mike. Bye-bye.